May it please your lordship. Your lordship, I beg to mention item number 6. Your lordship, here there's a new development in as much as the rules have been amended and they've also been published, your lordship. So we'll just require some time to go through the amended rules.
How will that affect the petitioner?
Because Lordship, they are seeking to revise the rules, Lordship. This is a promotion matter pertaining to the officers of Education Department. Since time and time again, the state has said that they'll relook into the rules. So now they have done that, Lordship. Let it come on board so that even we are not aware whether the rules have been published or not. So if the rules is ready, Lordship, then they can...
You bring the rules on record?
Yes, your lordship.
Heard Ms. Adinukari Lanerji was submitted that new developments have arisen as far as the proceedings in this case are concerned, in as much as the government have now brought out the relevant rules, the same having been duly published in the official gazette. Such rules would impact the course of action as far as the case of petitioner is concerned. It is therefore prayed that the said rule may be brought on record by way of an additional affidavit. On premier, the same is allowed. This is matter up to
2 weeks, your lordship.
why 2 weeks? You could have brought
Let it come after 10 days then, your lordship.
this matter up to 2 weeks.
Obliged, your lordship.
Hello.
Supplementary list, item number 1.
May I please your lordship?
Yes.
It's a regular bill, your lordship, and I'm in judicial custody for last 1.5 years, your lordship. It's regarding NDPS Act. Lordship, the brief fact of the case is that
What is your case?
Lordship, an FIR is lodged on 19/6 of 2023. If I may take your lordship, page number 13, the FIR, your lordship. May I please, your lordship? With reference to the subject cited above, I am inform you that page 13, your lordship, Annex 1, 13.
Yes.
With reference to the subject cited above, I am to inform you that about 5:15 p.m. received information from Shri P. Jarva and PS Additional Superintendent of Police, East Chandiya Hills District, that one Tata Tigor, white color, bearing registration number TR01BT 0265 was signaled to stop, but the vehicle drove in a very rush and negligent manner with a high speed, thereby about to kill the ANTF staff and the police personnel at Nongsing Naka, and thereby endangering of the life of police personnel present at the Naka. However, at about 5:45 p.m., the vehicle was detained near Clariot Police Station, and 2 occupants, namely Jarnal Das, son of so-and-so, second Pranay Masudar, son of so-and-so from Tripura, were detained, and one of the occupant, namely Gaurav Gupta, son of so-and-so, South Tripura, fled away from the vehicle, and the villagers and the police were able to detain him after a small chase in the process, and the said person were beaten up by the villagers and sustained a minor injury on his person. On initial interrogation, the detained person voluntarily stated that the said vehicle is loaded with illegal contrabands. Further, the detained person, Jarnal Das, also stated that the owner of the vehicle owner of the vehicle and the contravenants, namely Shri Karanjit Sarkar, son of so and so from South Tripura, and of his three friends were traveling in a Hyundai i20 bearing registration number so and so, and all of them were aware of the contrabands and were transporting it intentionally of smuggling to make money by selling it illegally. Lordship, here what happened, this particular person, Shri Joinal Dash, has informed the police that Karanjit Sarkar is the owner of the particular vehicle of the white Tata Tigor white color, and I was traveling with Karanjit Sarkar in his vehicle on that particular day in order to visit to my relative house in West Bengal. And that journal dash, he has informed the police that I am also aware of that contrabands, which I don't have any idea regarding that contrabands. I was traveling, and on the midway I got caught from the police, and that time I only know that there was something happening. They caught the Tata Tigor and there are some contrabands, and that Karanjit Sarkar is the owner of the vehicle. Lordship, I'm not ever. Only the thing was that I was traveling along with the Karanjit Sarkar. That was not my vehicle. I have nothing to do with the contrabands. That's all, Your Honor. Lordship, at this stage, charge sheet has filed, and I humbly pray Your Lordship, kindly call the case record, Your Lordship, at this stage.
What is the stage of the case?
Lordship, actually, in that trial court, we don't have any advocates, so I'm not aware of that stage of the case right now. So kindly call for the case record.
You don't know whether charges have been framed, evidence recorded. You don't know.
No, Your
You
Lordship.
have been aware.
Your Lordship, kindly call for the case record, Your Lordship, at this stage.
Fine. It is your duty to apprise the court of the
We have to take instruction, Your Lordship, on that.
I mean all the latest development.
Your Lordship,
Yes,
we have
Mr.
to take
Gurung, what is your
instruction.
Since this case stands charge sheeted, definitely the petitioner should be in possession of a copy of the charge sheet. Now that apart, my lord,
Yes. I think copy of the charge sheet is here.
Yes, we have attached, Your Lordship.
whether a complete charge sheet is there or not, and what is the stage of the my lord trial, that is absolutely, my lord, is correct. But however, at this juncture, my lord, I don't see the necessity to to roll back the LC record, my lord. For the fact that, my lord, look at the nature of the offence, the conduct of the petitioners, my lord, let me come to that, my lord. Firstly, my lord, on reliable information, my lord, and NACA was being conducted. Now, this is not a case of, my lord, only NDPS simpliciter, my lord. That apart, there is another section involved, 307, my lord. Because when NACA was being, my lord,
See, that 307 does not involve the particular person.
that is there.
I think he is an occupant. He was the occupant of another vehicle,
Another vehicle, Your Lordship.
That is there.
and that vehicle was not intercepted at the Naka.
Be that as it may, my lord.
Okay.
Now, the petitioner herein, my lord, as lordship has rightly pointed out, was the following, my lord, the second vehicle where the occupants were, my lord. These occupants were the actual, my lord, owner of this contraband, my lord. That has been revealed when 161 statement were recorded. Look at the, my lord, 161 statement of the petitioner itself, my lord. Kindly come to, my lord, page page 28, my lord.
Commercial quantity or
Commercial quantity, my lord. If I may read, my lord. My name is Sujit Sarkar, the petitioner herein, my lord.
petitioner is not.
Yes.
Petitioner is Monoranjan Mudab.
Second one.
Second one is Shudhi Sarkar. Item number 1 is Dr.
Then we'll come to, my lord.
Yes, Mohan. This petitioner is the accused.
Is
Yes.
the accused, Your Lordship. No, Your Lordship. The petitioner is not the accused. The petitioner is the cousin brother of the accused.
So you're referring here to the what's the name of the accused?
Accused is Tutun Sarkar and Sujit Sarkar.
Tutun Sarkar. Okay. And Mr. Gurung is referring to the statement of
The second petitioner, my lord. I'm sorry.
yes. Statement of accused person Tutun Sarkar.
Yes. My lord will come to page 26. The statements of the, my lord, the first car that was being, my lord, apprehended by the policeman.
Yes.
If I may read, my lord. My name is Joel Das, son of so-and-so, resident of so-and-so. I, along with Sri Karanjit Sarkar, Sri Sujit Sarkar, and Sri Tutan Sarkar and Sri Sanjit Sarkar, the name of the petitioner is reflected here, my lord, went to Sonamora to purchase the contraband ganja from one unknown tribal person, and the same is loaded in my vehicle, Tata Tiger. On 18/6/2023 at around 6:30 am, I, along with Sri Parnay Majumdar and Sri Gaurav Gupta, left Tripura by my vehicle so-and-so, Tata Tiger. I, along with Sujit Sarkar, Sri Tutan Sarkar is the petitioner here, Sri Sanjit Sarkar and Sri Karanjit Sarkar had collectively purchased the contraband from one unknown tribal man from Sonamara. There are two vehicles, that one is mine and the other belong to Sri Karanjit Sarkar, bearing number so-and-so Hyundai i20. But the said contrabands were loaded in my vehicle, accompanied by two of my friends, Sri Parnay Majumdar and Sri Gaurav Gupta. Whereas Sri Karanjit Sarkar, Sri Karanajit Sarkar, Sri Sujit Sarkar, Sri Tutan Sarkar and Sri Sanjit Sarkar are boarding. On reaching Silchar, all of us stayed in one of the hotel. On 19/6/2023 at around 7 am, all of us left Silchar for Sri Rampur via Meghalaya. Our vehicle crossed Sonapur, Meghalaya at around 3 pm, and I followed I-20 vehicle from behind, as the I-20 vehicle occupants were acted as informants regarding safe passage of my vehicle. On arrival at one of the Naka checking before reaching Khalerihat, my car was stopped by the police for checking, but out of fear I sped up and my car and fled away. But I was chased by police vehicle. In the process, I dashed the police vehicle many times, and as a result, the police chased by police vehicle. In the process, I dashed the police vehicle many times, and as a result, the police vehicle caused damage. So the vehicle of the police was also damaged. When my vehicle was detained near Khaleriat PS, all three of us tried to run away, but the police caught me, and Sri Parnay Majumdar and Sri Gaurav Gupta managed to flee. However, police ran after him, and the local people also started to chase him, and Sri Gaurav Gupta was caught by the local people, and he was beaten up. As a result, he had minor head injury. All three of us were brought to Khaleriat PS, and all the contraband that was loaded in my vehicle booth were seized by the police at Khaleriat PS. I am also to state that I was asked by Sri Karanjit Sarkar to carry the contraband, and he is the main supplier of ganja, and he had done it earlier also. That means he is a habitual offender, my lord. Sri Karanjit Sarkar had promised to bond all the expenditure regarding the fooding and fueling of my vehicle, and also to give rupees 20,000 after delivering the consignment at Sri Rampur. Sri Parnay Majumdar and Sri Gaurav Gupta, who were sitting with me in my vehicle where I was driving my vehicle, I am to state that both of them knew that I was carrying contraband, and Sri Karanjit Sarkar also promised to give both of us rupees 20,000 by vehicle number so and so. Tata Tiger was registered in my name and it belonged to me. The vehicle was purchased by me as I had taken the money from my father-in-law, Sri so and so. So, my lord, the 161 of almost all the accused is similar, my lord. It is an admitted fact that actually the vehicle that was moving ahead of the vehicle that was carrying the consignment, my lord, were being, my lord, they were kind of, my lord, they were signaling the car that was following them whether the passage is safe or not, my lord. And that apart, my lord, that the occupants of the vehicle where the consignment was, my lord, found, seized, has categorically stated that it was the front vehicle where Karanjit Sarkar and his occupants are there. They were the actual owner of the, my lord, consignment, my lord. So therefore, my lord, these were seized. Now the look at the quantity of the, my lord, seized consignment. It is commercial quantity, my lord. So when once it is a commercial quantity, my lord, to avoid the repetition, my lord, I am relying on lots
What
of.
is the statement of the accused person in question? Page 29, 28, 29.
This is Sanjit Sarkar.
No, this is, we are talking about Tutan Sarkar.
Total. Is there any statement total?
Page 29. 28, last part.
Yes. This is Gaurav Gupta.
May I please, Your Lordship? Lordship.
Yes, it is here, my lord.
He is,
At page 28,
accused,
last paragraph, my lord.
Tutan Sarkar is the accused.
May,
Lordship is already stated in the FIR that Jewel Dash he gives the information to the police that that Karanjit Sarkar along with the accused person they are owner of the contrabands and they are aware of the contrabands. So his statement is same only. If I may take Your Lordship,
No, my lord, this is-
independent statement of witnesses, Your Lordship.
no, first we'll see what you have to see. I mean,
what you have stated, that
the
will say the
accused
petition.
person says.
May I, my lord? My name is Sri Tutan Sarkar, 31 years old, son of so-and-so, resident of so-and-so, Tripura. On 17/6/2023, I, along with Sri Sanjit Sarkar, Sri Sujit Sarkar, Sri Karanjit Sarkar, and Sri Joel Das, went to Sonamara. I was hired by Sri Karanjit Sarkar, my neighborhood, to drive his vehicle. So he was driving the first vehicle, my lord, for a period of 5 days, and promised to give me rupees 5,000, and all expenditure spent on fooding and etc. will be borne by Sri Karanjit Sarkar. The contrabands were collectively purchased by us by contributing money from one tribal fellow from Sonamara, and loaded the same in the vehicle of Joel Das, number so and so. We were supposed to carry the contraband to Sri Rampur, and Karanjit Sarkar told me that one person by the name of Nitish would purchase the same from Sri Rampur Assam border. Thus, me, Sri Karanjit Sarkar, Sri Sujit Sarkar, Sri Sanjit Sarkar, and Sri Joel Das are all collectively had contributed in purchasing and planning the transportation of the contraband. Sri Parnay Muzumdar and Sri Gaurav Gupta were along with us, helping us in loading the contraband and for transporting the same, and traveling along with Sri Joel Das in his vehicle number so and so. On 18/6/2023, we all left Tripura and halted at Silchar in one of the hotel, and on 19/6/2023 at around 7 am, we left Silchar for Sri Rampur. Both the vehicles were traveling together and had crossed Sri Rampur landslide after 2 p.m. But on reaching at one of the Naka at Cleriat, Sri Joel Das fled away. The Naka is a very high in a very high speed, and one police vehicle chased him. I was driving the vehicle Hyundai i20 of Sri Karanjit Sarkar and traveling along with Sri Sanjit Sarkar, Sri Sujit Sarkar, Sri Karanjit Sarkar, and we were checked at the Naka, but the police found nothing from our vehicle possession, and so we were allowed to go. But on reaching at Kongnong, our vehicle and all of us detained and brought us all by police to Calicut PS, where I saw that Sri Joel Das, Parnay Muzumdar, and Sri Gaurav Das were already detained, and saw that Joel Das vehicle was parked in Calicut PS. So, my lord, this reveals that, my lord, I don't have to say anything, my lord.
This is your own statement.
Lordship, but nothing has proof.
No, that is a matter of trial.
Lordship.
Because at this stage, what the court has to look into is only your prima facie complicity or involvement. In course of trial, it may be proved right or wrong. That is not a concern of this court. But considering the fact that you see Section 37 is involved,
Yes, Lordship.
and the court, like I said again, prima facie is not convinced that you are innocent.
Your Lordship.
So if that goes, then one of the requirement of 37, Section 37, right.
Lordship, nothing has revealed from my position, not even from my car.
But
Still, trial is
you
going
see,
on.
association is there.
Yeah.
I don't know whether Section 29 is here.
Yes, my lord.
Lordship, my only humble prayer at
Conspiracy
this
is there.
stage, Your Lordship, kindly call the case record, Your Lordship.
Where is that?
This is the charge sheet. I'm very sorry, miss. I don't think I can help you. Okay, NDPS. All these two cases same,
Same, my lord.
different
Different
accused.
accused, Your Lordship.
And joint common order. These two petitions have been filed with a prayer for grant of bail on behalf of the accused person, namely Shri Tutan Sarkar, and the other one is Shri
Sujit Sarkar, Your Lord.
Vijit Sarkar, who are involved in a case registered as what is the case number?
Yes.
The Clear PSK something.
It's Hilariat PS case number 47/6/2023 and special NDPS case number 25 of 2023.
Okay. Clear PS case number under section IT section 1. This letter counsel for the petitioner has submitted that the accused person in question were occupants of a vehicle bearing number TR01 BW 0231. They were in this vehicle.
Yes.
Lordship, they are
He was
driving this vehicle.
driving I-20 bearing TR 01 BW 0231. But the contraband they have.
Okay, but they are occupants of,
He was driving.
which was driven by
The petition.
accused person Tutan Sarkar. The Land Council has submitted that on when was the date?
17/6/2003.
On 17/6/2003, one vehicle driven bearing number TR01 BT 0265, driven by one Shri Joyal JOYEL Joyal Das, was intercepted during Naka.
My lord, date of interception is 19, my lord. They started on 17.
19 was intercepted at the where is the at Nongsning near BMS fuel station, East Jante Hills, whereupon the police personnel upon conducting a search of the vehicle had discovered a large quantity of alleged contraband substance. Accordingly, the occupants of the said vehicles were all arrested and booked under the relevant provision of the NDPS Act. During investigation and examination of the said occupants of the said vehicle, it is the statement of accused person Joel Das that the contraband belongs to one Shri Kar,
Karanjit Sarkar.
Karanjit Sarkar. He was also occupant of the other vehicle,
Karanjit Sarkar, yes.
who was the occupant of another, who was the occupant of the vehicle driven by the said accused person Tutan Sarkar. Accordingly, on such complicity being linked, the occupants of the said vehicle number, first vehicle,
TR01 BW
yeah,
0231 Hyundai i20.
we are also arrested, and we are also arrested in connection with the said case. Next, in course of investigation, the IO had noted the statement of several witnesses, including the accused person, such statement being recorded under section 161 of CRPC. And eventually, on finding a prima facie case well established against the accused person, the IO had put up the matter for a proper trial before the competent court of jurisdiction, wherein the case is now registered as, what is the
Is
as NDPS case number
is number 25 public 2023.
23, to be tried by the learned special judge NDPS at Clear East and Hills. The learned counsel for the petitioner has, however, submitted that the accused persons whom she is representing are not at all involved in the case, inasmuch as the alleged contraband substance was not seized from the vehicle they were traveling, but they were implicated by the said Shri Joel Das and others without any proof of their involvement in the case. The accused person, having been incarcerated in custody for how many months?
1 year.
1 year 5 months, man.
For about 1 year 5 months. It is therefore prayed that the prayer made for grant of bail may be allowed with any condition to be imposed by this court. Per contra, Mr. Armuru Leonard GA has strongly opposed the prayer made and has led this court to the petition itself, particularly at page 28 and 29 of the same, led at page 26 of the same, wherein is found the statement of Shri Joel Das, who has clearly given the details of how the incident had taken place, and that the said contraband was indeed discovered from his vehicle, from the vehicle he was driving. This Joel Das was the driver.
Uh, yes.
Vehicle he was driving. Further, the said jewelers has also stated that the said contraband good belongs to one Karnajit Sarkar, who was proceeding in the other vehicle, that is TR01BW0231,
Hyundai.
along with the accused person's name herein. Therefore, under such circumstances, there is no doubt that the accused persons in question are involved in the whole involved in the case. In fact, from the statement of the above two accused person recorded by the police under section 161 CRPC, the same facts have been stated and admitted by them. To the extent that they have not denied that there exists the contraband which was stored in the said vehicle driven by Shri Joel Das, and that the same belonged to said Karnajit Sarkar, who had offered them money to accompany him. The learned J has submitted that under such circumstances, the prayer of the petitioner may not be allowed, and the trial may be allowed to be carried out in this regard. This court has given a thoughtful consideration to the submission made. Firstly, it is not denied by the parties that alleged illegal contraband substances was indeed seized from the said vehicle number TR 01 BT 0265. The fact that the two named accused herein are occupants of the other vehicle was also not denied by them. Though it is claimed that they have no knowledge or involvement as far as the said illegal, as far as the matter concerning the said alleged illegal contraband substance is concerned, their link to the alleged owner of the said contraband substance and the proximity of the two vehicles when the same was intercepted at the said Naka checkpost has also been borne out by records. Next, it is also evident that the case was registered under the relevant provision of the NDPS Act. including section 20 under bracket B, small b, under bracket 2, small 2, Romans 2, under bracket
See.
B, big capital B, which speaks of seizure of contraband, alleged contraband substance of commercial quantity. Next, this leads this court to another aspect of the matter, that is the provision of section 37 of the NDPS Act 1985, wherein it is stipulated that any case concerning seizure of commercial quantity of contraband substance, that in any case concerning to when bail is to be considered, the same may not be allowed unless firstly the public prosecutor is given notice of the hearing of such application for bail, and secondly, if the court is of the opinion that the accused person in question is innocent. Next, as indicated above, prima facie, this court is not convinced that the accused person in question are innocent prima facie, and thus being hit by the provision of section 37, wherein grant of bail is generally taken in the negative sense rather than the positive. Therefore, under such circumstances, this court is not inclined to allow the prayer made in this petition. Petition dismissed as devoid of merit and disposed of accordingly.
Deeply honest.
Let's see how the trial goes.
Lordship.
There is another window open for you.
Lordship.
If there's a delay in trial, then you can always come. We'll see after 2-3 years.
Item number 3.
Yes.
My lord, yesterday I had commenced my submissions. Time had already been up, so my lord fixed it for today. My lord, I was referring to the judgment of Pankaj Bansal. Permitted, I'll continue from where we left yesterday, my lord.
Have you?
I had submitted the judgment, my lord. Para 32, internal page 737.
Yes.
May I, my lord? That being so, there is no valid reason as to why a copy of such written grounds of arrest should not be furnished to the arrested person as a matter of course and without exception. There are two primary reasons as to why this would be the advisable course of action to be followed as a matter of principle. Firstly, in the event such grounds of arrest are orally read out to the arrested person or read by such person with nothing further, and this fact is disputed in a given case, it may boil down to the word of the arrested person against the word of the authorized officer as to whether or not there is due and proper compliance in this regard. In the case on hand, that is the situation insofar as Basant Bansal is concerned, though the ED claims that witnesses were present and certified that the grounds of arrest were read out and explained to him in Hindi, that is neither here nor there, as he did not sign the document. Non-compliance in this regard would entail release of the arrested person straight away as held in V. Senthili Balaji. Such a precarious situation is easily avoided and the consequences thereof can be obviated very simply by furnishing the written grounds of arrest as recorded by the authorized officer in terms of section 19(1) of the Act to the arrested person under due acknowledgement instead of leaving it to the debatable ipse dixit of the authorized officer. The second reason as to why this would be the proper course to adopt in the constitutional objective underlying such information being given to the arrested person, conveyance of this information is not only to appraise the arrested person of why he/she is being arrested, but also to enable such person to seek legal counsel and thereafter present a case before the court under section 45 to seek release on bail if she so chooses. In this regard, the grounds of arrest in V. Senthili Balaji are placed on record, and we find that the same run into as many as 6 pages. The grounds of arrest recorded in the case on hand in relation to Pankaj Bansal and Basant Bansal have not been produced before this court, but it was contended that they were produced at the time of remand. However, as already noted earlier, this did not serve the intended purpose. Further, in the event their grounds of arrest were equally voluminous, it would be nay, possible for either Pankaj Bansal or Basant Bansal to remember all that they had read or heard being read out for future recall as to avoid legal remedies. More so, as a person who has just been arrested would not be in a calm and collected frame of mind and may be utterly incapable of remembering the contents of the grounds of arrest read by or read out to him. The very purpose of this constitutional and statutory protection would be rendered nugatory by permitting the authorities concerned to merely read out or permit reading of the grounds of arrest irrespective of their length and detail. The claim due compliance with the constitutional requirement under Article 22(1) and the statutory mandate under Section 19(1) of the Act of 2002. We may also note that the grounds of arrest recorded by the authorized officer in terms of Section 19(1) of the Act would be personal to the person who is arrested, and there should ordinarily be no risk of sensitive material being divulged therefrom, compromising the sanctity and integrity of the investigation. In the event any such sensitive material finds mentioned in such grounds of arrest recorded by the authorized officer, it would always be open to him to redact such sensitive portions in the document and furnish the edited copy of the grounds of arrest to the arrested person so as to safeguard the sanctity of the investigation. From the above analysis, to give true meaning and purpose to the constitutional and statutory mandate of Section 19(1) of the Act of 2002 of informing the arrested person of the grounds of arrest, we hold that it would be necessary henceforth that a copy of such written grounds of arrest is furnished to the arrested person as a matter of course and without exception. The decisions of the Delhi High Court in Moin Akhtar Qureshi and Bombay High Court in Chhagan Bhujbal, which hold on the contrary, do not lay down the correct law. In the case on hand, the admitted position is that the ED's investigating officer merely read out or permitted reading of the grounds of arrest of the appellants and left it at that, which is also disputed by the appellants. As this form of communication is not found to be adequate to fulfill compliance and the mandate of Article 22(1) of the Constitution and Section 19(1) of the Act, we have no hesitation in holding that their arrest was not in keeping with the provisions of Section 19(1) of the Act of 2002. Further, as already noted, the clandestine conduct of ED in proceeding against the appellants by recording the second ECIR immediately after they secured interim protection in relation to the first ECIR do not commend acceptance, and it seeks to arbitrary exercise of power. In effect, the arrest of the appellants and in consequence the remand to the custody of the ED and thereafter to judicial custody cannot be sustained. The appeals are accordingly allowed, setting aside the impugned orders passed by the division bench of the Punjab and Haryana High Court, as well as the impugned arrest orders and arrest memos, along with the orders of remand passed by the learned vacation judge, additional session judge Panchkula, and all orders consequential thereto. The appellant shall be released forthwith unless their incarceration is validly required in connection with any other case. My lord, this was decided on October 2024. My lord,
See this section 19(1).
My lord, this corresponds to section 19(1) is of the PMLA Act. PMLA Act. It's an economic offence. However, my lord, the subsequent judgments referring to the said judgment says it is extendable to all other laws. under which an arrest is being made, akin to section 50 of CRPC, my lord. My lord, next judgment I would be relying upon is Prabir Prakashta, if I may, my lord. My lord, para 20, page 24.
Yes.
My lord, here they have followed the law as laid down in Pankaj Bansal, which we have gone through. My lord, if I may, para 20, please. Resultantly, there is no doubt in the mind of the court that any person arrested for allegation of commission of offences under the provisions of UAPA, or for that matter any other offence, has a fundamental and a statutory right to be informed about the grounds of arrest in writing, and a copy of such written grounds of arrest have to be furnished to the arrested person as a matter of course and without exception at the earliest. My lord, they have covered here not just PMLA, they are drawing the inference from Pankaj Bansal's matter. They are saying not just UAPA, which is one of the most stringent laws, but as a matter of fact, any other law. The purpose of informing to the arrested person the grounds of arrest is salutary and sacrosanct in as much as this information would be the only effective means for the arrested person to consult his advocate, oppose the police custody, remand, and to seek bail. Any other interpretation would tantamount to diluting the sanctity of the fundamental rights guaranteed under Article 22(1) of the Constitution of India. The right to life and personal liberty is the most sacrosanct fundamental right guaranteed under Article 20, 21 and 22 of the Constitution of India. Any attempt to encroach upon this fundamental right has been frowned upon by this court in a catena of decisions. My lord, they are referring to the past decisions, all holding the same principle. My lord, para 22.
Yes.
The right to be informed about the grounds of arrest follows from Article 22(1) of the Constitution of India, and any infringement of this fundamental right would vitiate the process of arrest and remand. Mere fact that a charge sheet has been filed in the matter would not validate the illegality and the unconstitutionality committed at the time of arresting the accused and the grant of initial police custody remand to the accused. My lord, para 25.
Yes.
A constitution bench of this court examined in detail the scheme of Article 22(5) of the Constitution of India in the case of Hari Krishna versus State of Maharashtra and others, and held that the communication of the grounds of detention to the detainee in writing and in a language which he understands is imperative and essential to provide an opportunity to detainee of making an effective representation against the detention, and in case such communication is not made, the order of detention would stand vitiated as guaranteed under Article 22(5) of the Constitution was violated. The relevant para is extracted herein below. My lord, referring to a past judgment. My lord, para 26, they are again reproducing as has been held. My lord, para 30 and 31, where the court sums up. Page 29.
Page 29.
My lord. Page 29, para 30, para 31. If I may.
Yes.
Hence, we have no hesitation in reiterating that the requirement to communicate the grounds of arrest or the grounds of detention in writing to a person arrested in connection with an offence or a person placed under preventive detention as provided under Articles 22(1) and 22(5) of the Constitution of India is sacrosanct and cannot be breached under any situation. Non-compliance of this constitutional requirement and statutory mandate would lead to the custody or the detention being rendered illegal, as the case may be. Furthermore, the provisions of Article 22(1) have already been interpreted by this court in Pankaj Bansal, laying down beyond the pale of doubt that the grounds of arrest must be communicated in writing to the person arrested of an offence at the earliest. Hence, the Fraudulent plea of the state, Your Honor, Lordship, is being rejected. My Lord, para 44, page 37, court continues.
Yes.
May, my Lord. Para 44. We do not feel persuaded to examine these aspects at this stage because the same would require entering into the merits of the case. This would be within the domain of the court examining the matter after filing of the charge sheet. The core issue in this appeal is regarding the illegality of the process whereby the appellant was arrested and remanded to police custody, which does not require examining the merits of the case. My Lord, para 45. It was the fervent contention of learned ASG that in the case of Ramkishore Arora, a two-judge bench of this court interpreted the judgment in the case of Pankaj Bansal to be having a prospective effect, and thus the ratio of Pankaj Bansal cannot come to the appellant's aid. Indisputably, the appellant herein was remanded to police custody on 4th October 2023, whereas the judgment in the case of Pankaj Bansal was delivered on 3rd October 23. Merely on a conjectural submission regarding the late uploading of the judgment, learned ASG cannot be permitted to argue that the ratio of Pankaj Bansal would not apply to the present case. Hence, the plea of Shri Raju would not apply to the proceedings of remand made on 4th October. My Lord, the court has very firmly come and said that the law as has been laid down in Pankaj Bansal will come into effect even if the judgment was uploaded at a later stage. My Lord, para 46, we are of the firm opinion that once this court has interpreted the provisions of the statute in context to the constitutional scheme and has laid down the grounds of arrest have to be conveyed to the accused in writing expeditiously, the said ratio becomes the law of the land, binding on all courts in the country by virtue of Article 141 of the Constitution of India, my Lord. My Lord, lastly, these principles have been summed up in Vihan Kumar, my Lord. It has been passed as recently as January 2025, my Lord, where the principle of Pankaj Bansal as well as Prabir Prakashto, if I may, my Lord.
Yes.
My Lord, the Honorable Justice N.K. Singh was sitting as one of the Honorable Puni's judges on the bench when this matter was taken up. The judgment, though, was primarily authored by His Lordship Justice Abhay S. Okha. However, where the principle has been affirmed by them, my Lord, instead of going into the repetition, Justice N.K. Singh gives a ascending note to the judgment. My Lord, page 37.
Para?
My Lord, para 2. It's concurrent judgment, my Lord.
Yes.
May I, my Lord? My Lord, the second last line, the constitutional mandate, para 2.
Yes.
May I? The constitutional mandate of informing the grounds of arrest to the person arrested in writing has been explained in the case of Pankaj Bansal so as to be meaningful to serve the intended purpose which has been reiterated in Prabir Prakashto. The said constitutional mandate has been incorporated in the statute under section 50 of the CRPC and section 47 of the BNSS. It may also be noted that the aforesaid provision of requirement for communicating the grounds of arrest to be purposeful is to be required to be communicated to the friends, relatives, or such other person of the accused as may be disclosed or nominated by the arrested person for the purpose of giving such information as provided under section 50A of the CRPC. As may be noted, this is in the addition to the requirement as provided under section 51 of the CRPC. The purpose of inserting section 50A of the CRPC, making it obligatory on the person making arrest to inform about the arrest to the friends, relatives, or persons nominated by the arrested person, is to ensure that they would be able to take immediate and prompt actions to secure the release of the arrested person as permissible under law. The arrested person, because of his detention, may not have immediate and easy access to legal process for securing his release, which would otherwise be available to the friends, relatives, and such nominated persons by way of engaging lawyers, briefing them to secure release of the detained person on bail at the earliest. Therefore, the purpose of communicating the grounds of arrest to the detainee and in addition to his relatives, as mentioned above, is not merely a formality but to enable the detained person to know the reasons of his arrest, but also to provide the necessary opportunity to him through his relatives, friends, or nominated persons to secure his release at the earliest possible opportunity of actualizing the fundamental right to liberty and life as guaranteed under Article 21 of the Constitution. Hence, the requirement of communicating the grounds of arrest in writing is not only for to the arrested person but also to the friends, relatives, or such other person as may be disclosed or nominated by the arrested person, so as to make the mandate of Article 22(1) of the Constitution meaningful and effective, failing which such arrest may be rendered illegal. My Lord, page 44, annexure 5.
Yes.
This is my intimation of arrest, my Lord. If I may.
Yes.
To Sabita Gupta, wife of Shri Pankaj Gupta, resident of Tura, reference Bajingdoba PS case number 14524 under section so and so. Madam, it is to intimate you that Shri Pankaj Gupta @Pintu, who was been arrested in connection with the case under reference at Tura on 14/1/2025 at 5:30 am, has been held in custody at Bajingdoba PS lockup under police custody, sent to Dash under judicial custody. It is further informed that the below mentioned articles were recovered during the search of the arrested person, is to be handed over to you as desired by the arrested person. You may collect the same from this police station on any working day. If you do not collect these articles, the articles shall be kept in police station for safe custody and shall be returned to the arrested after release or if ordered by the court. Description: nil. Intimation of arrest, grounds of arrest, nil. Now, my lord, this case, the alleged incident dates back to...
But this has been received.
It has been received, but the grounds of arrest are not mentioned, my lord. The judgments which we have gone through, my lord, they categorically state that the grounds of arrest have to be given in writing.
Okay. The grounds of arrest has to be given, drawn up in writing
In writing.
and shown or handed over to the friend or
Handed
relative
over
or-
to the accused and to his nominated relative. My lord, the last judgment of Vihan, the note which has been provided by Honorable Lordship N.K. Singh, he says that not just to the accused but also to the relative to fit the scheme of the law. Else the arrest will be rendered illegal. They have come down very clearly, my lord, over there. My lord, not just this, the incident originates allegedly...
So nowhere in the proceedings was the ground of arrest drawn up.
My lord, if it was given to me in writing, it should be on record. Now, this is on record, this is an intimation of my arrest. Because when I am arrested, I have to be informed. My lord, it reads, intimation to the nominee of arrested person.
Yes.
There are no grounds of arrest that have been mentioned. Now, my lord, that being said, the incident allegedly as per the FIR is of a period of 2022. In the FIR, the complainant also says that he has brought in buffer stock to fulfill the discrepancy which existed. Now, my lord, he knew about this incident. It's an allegation upon me, my lord, not conceding to it, only seeing the FIR, that in 2022 the complainant knew about this incident. But he waits till 2024 and he says the only reason for filing this FIR is because I have failed to answer his calls. It has been endorsed. Now, my lord, after the filing of the FIR on 15th or 16th of May 2024, I was served a notice under 41A on 22nd of May 2024. My lord, it is also an admitted position that I have abided by that 41A notice and have gone and appeared before the police and have continued to cooperate with them. Now, my lord, as recent as my lord, on 28, the Apex Court, while deciding an anticipatory bail in Pradeep Sharma's matter, has stated that in an offence where the offence is of documentary in nature, the custody of an accused may not be required and custodial interrogation may not be required. Now, in my case, my lord, I have been abiding by the 41A notice for a period of 8 months. Now I have been arrested, grounds were not told, have not been published rather, my lord. If they have to be in writing, they should have been published by the concerned officer. Post that, my lord, when I was produced before the judicial magistrate for my remand, the medical doctor has given a clear-cut opinion that I am not fit to be kept in custody. If I may draw, my lord, page number 48, annexure 7. If I may.
Yes.
My lord, the type copy is at page 49 onwards. And page 50 in the opinion.
Yes.
May I, my lord?
Page 50.
Page 50, my lord, the type copy. Last line.
Yes.
My lord, the opinion,
Yes. Yes.
the doctor says that I am not fit to be kept in a lockup.
If you are not fit to be kept in a lockup, so what is required is for the authorities to refer you to a hospital.
My lord, but in my case,
Has that been done?
after your lordship's order, I have been taken for a medical checkup. After your lordship's order, when I moved the bail, I have been taken. But lordship, this is a very alarming and a dangerous trend which has cropped up. When it was written that I am not fit to be kept in a lockup, it is evident from the record that the doctor was called. Phone calls were made to the doctor and then a new medical came out, where it says that I am fit to be kept in a lockup.
Oh.
My vital readings have been changed. My lord, this be the case, my lord. My previous bails also, when they were rejected on the ground that I'll commit suicide, that I have stated that I will commit suicide. But my lord, nothing is present on record for me saying it.
Yes, Mr.
And sum up, my lord. As of now, I'm having kidney issues and I'm having liver issues, my lord. I need to go for my treatment. And I'm cooperating with the investigation.
Where's the medical record?
After my lord's order, the checkups have been done, where it has come.
Have you got the latest?
No, I am not in possession. I'm sure the state was asked to produce the same.
Okay. Yes.
May it please Your Lordship. Lordship, so far the ground of arrest as contended by my friend, Your Lordship, that was my humble and respectful submission, Your Lordship, that has been rendered in the context of the PMLA. That means that Money Laundering Act 2002, Your Lordship.
Oh, see.
Lordship, just a minute, Lordship.
Yes, Mr.
Lordship, in that case, Your Lordship, the judgment, Your Lordship, when I'm hearing is that henceforth, there is a word henceforth. So that mean in my humble and respectful submission, Your Lordship, pre-October 2024, Your Lordship, that judgment will not be applicable because this is a case of May 2024, Your Lordship, because it say henceforth, then it was subsequently followed, Your Lordship, in other cases, Your Lordship. That I'll agree. After the post October 2024, Your Lordship, if ground of arrest had not been furnished, then the arrest would become illegal as per the law laid down by the Honorable Supreme Court in those case cited, Your Lordship. But Your Lordship, kindly see in this case, Your Lordship, at page 41, Your Lordship, a notice has been issued, Your Lordship. This is being followed in view of the D.K. Basi judgment, Your Lordship, where intimation is required to be furnished to the relative of the arrested person, Your Lordship. Lordship, there is a wording that henceforth, Your Lordship. So that means, Your Lordship, in my humble and respectful submission, those decisions, Your Lordship, are not having retrospective, Your Lordship, are prospective in nature, Your Lordship. So will not be applicable in this case, Your Lordship. So far, the other contention, Your Lordship, of the bail applicant, Your Lordship, that he
Your case is a case of 2024.
May 24, Your Lordship. May 24, Your Lordship.
This
Judgment that is October 24. No, correct. No?
October 24, but I was arrested on January 25, my lord. After the judgment. My arrest has been effected after the judgment.
That intimation has already been given, Your Lordship. Then another aspect, Your Lordship, so far the accused is concerned, Your Lordship, a notice under 41A has been issued. It is a fact, Your Lordship, that he appeared and cooperated with the investigation, Your Lordship. Then, Lordship, the IO in his wisdom thought that in view of the seriousness of the case, Your Lordship, he deemed it fit to take the accused into custody, and that is why he has been arrested, Your Lordship. That is why he has been arrested. Then, Your Lordship, so far the medical condition, Your Lordship, after the order passed by this Honorable Court, Your Lordship, the accused has been taken for medical checkup, Your Lordship. Lordship, I have. It appears, Your Lordship, that he is the accused is having he's a diabetic, Your Lordship, diabetic patient, Your Lordship.
What is the opinion?
Lordship, Lordship, kindly come to the next that medical certificate, Your Lordship.
Yes.
Lordship, it appears that his blood sugar, Your Lordship, is fluctuating, Your Lordship.
But what is the?
Then, Lordship, I'll take Your Lordship straight away to Lordship. Kindly come to the last page. This is the medical report of 26/2.
26/2.
Lordship, it's very difficult because we are not medical I'm not medical, Lordship. Impression, Your Lordship. Kindly come. Left renal calculus mild hepatomegaly suggested clinical correlation and with other relevant documents, Your Lordship, which I do not understand what does it mean, Your Lordship. This.
Oh, this is the ultrasound.
Ultrasound, Your Lordship. Yes.
So, this report would only indicate the condition of the patient. But there must be some opinion of what is to be done.
Lordship, this is the only medical report, Your Lordship.
Whether he is required to be hospitalized, whether he is required
there is nothing as such, Your Lordship. There is nothing as such, Your Lordship. 26. This is with regard to since he's having a kidney problem, Your Lordship. This is with regard to his kidney.
Yes.
Lordship, yes.
My lord, the first is for kidney and the second is for liver, as far as my normal knowledge goes.
Lordship, kindly come first liver, Your Lordship. Liver.
Yes.
Enlarged and measures appear normal in outline. Parenchyma is normal in echogenicity and texture. No focal areas of altered are not noted. The intrahepatic biliary radical are not dilated. MPB, hepatic being normal. Lordship, it doesn't. And then gallbladder, it is normally distended. Then CBD is not dilated. Pancreas is normal in size and shape. Pancreas is normal. Spleen is normal in size, shape, and outline. Kidney, right, left kidney, both are renal calculus noted in middle left kidney. I don't know what does it mean. Calculus of size 5 mm noted in middle callus of left kidney. No height, no calculus. Uterus is not dilated. Unitary bladder, it is normally descended. Wall thickness is normal. No calculus. Prostate appear normal in size and shape. Is smooth and normal. No.
See, Mr. Sulai.
Lordship, yes.
I don't understand the
Lordship,
medical language. neither do you. So, there's a phrase they used to say, is there a doctor in the house? There's no doctor here.
Lordship, I also, to be to be fair, Lordship, also I cannot
What we can do,
make out your Lordship.
What we can do, Mr. Shulai,
Lordship,
I've heard the parties. I just want to confirm on the medical condition of the patient or the accused. We'll defer this matter for a while. In the meantime, if you don't mind,
Lordship,
you take this this report and just show it to our doctor, just to get her opinion
Lordship,
of the record, just to get her opinion. What is this about?
whether he needs
Either of you can.
or whether he need hospitalization.
What would be the actual condition of the?
My lord, if I may be of some assistance here, I'm also not a doctor, but then what the report says is that I have a stone in my kidney and my liver is enlarged.
What is the stone? Every one of us has stone in kidneys. What would be the severity of it?
My lord, I will have to go and get into a proper hospital for a checkup because I am having sugar also.
But for the sake of just trying to clarify on this report, what does it actually says in layman's term? We have a doctor here.
Lordship, just for a while, I'll just go and.
Two of you can go.
Yes,
just to, so we'll take up other cases in the meantime.
Lordship, yes. Lordship.
Daily list, item number 1.
We have to place it on record.
Yes.
My lord, in this matter, it is confirmed that my lord, default bail has been granted.
Where is the order?
We'll place it on record in the course of the day, my lord. Sometimes in the month of January, my lord, bail was granted. We'll place it on record, my lord.
It will be listed on Friday then. So let it bring it through proper because this has got a far-reaching effect and any case other issues are involved.
No, but then
Simply withdraw it otherwise. The purpose is served.
that would be one course. Otherwise, you see, this court has to make certain observation.
Correct.
When the matter, for grant of bail is pending before a higher court, I don't see any case, any related case concerning the same accused person being pending in other higher courts than this,
Correct.
either in DV or Supreme Court.
Absolutely correct. Yes.
But we would presume that it pertains to cases before trial court or any other court. Why would that court take cognizance of the matter, issue relevant orders, for bail or otherwise, when
Matter sub judice before the High Court.
course is in season of this matter?
That is a very important issue. There's no doubt about it. And there's an affidavit also that there is no other bail petition.
Yes. My lord, we have not filed the bail application, my lord. Court suo motu, my lord. After the lapse of time period, my lord, court suo motu had granted default bail, my lord. It's not that we had preferred. That's why we are also not aware. Bail was granted sometime in the month of January, my lord. Since we are pursuing the matter before this honorable court, so we are not appearing before the trial court, my lord. They were just simply, my lord, they were.
It was just a bonus handed over to you. No,
This is serious.
but that has, otherwise, as Dr. Mursika said, it's up to you.
Nothing. Up to him.
If you want to withdraw the application, matter ends there.
Kindly allow me, my lord, to place it on record. May have this matter tomorrow. I'll place that on record. Thereafter, my
Once you place that on record, this court will make that observation.
I'll pass necessary orders thereafter, my lord.
Please it tomorrow.
We'll place it tomorrow, my lord.
Okay. Why don't you simply withdraw it to close the matter? What is the harm in that?
Take instruction also.
Senior involved, he involved.
In the meantime, I'll take instruction also, my lord. I'll place the data on record, and in the meantime, I'll take instruction also, my lord. Kindly grant me time till tomorrow, my lord.
On permit by the Internet Consultation. This is matter tomorrow. So tomorrow?
Tomorrow, my lord.
Item number 3.
Yeah, please, Your Lordship. Your Lordship.
This is the check gate matter, my lord. We have filed a miss case after that, madam.
I think what is required now, as far as interim protection is concerned, I don't think this court has passed status quo order, that will remain.
No, my lord, the status quo order is not serving anything, my lord, because the check gate was already closed down by the police.
That is why.
On last occasion, what your lordship directed me to file a miss case for that, my lord, because there was no miss case for stay on record. So that we filed.
But an effective order has already been passed.
But in fact, we are asking for a stay of the.
See why this court was. I mean, initially, when the proceedings started, this court was under the impression that you had sought for a stay order or interim order only to ensure that your check gate is intact or whatever you're doing you would continue to do. But that is past now.
But in my humble submission, I'll just place my few decisions, my lord, and then your lordship will continue. Because on last occasion, why your lordship stopped sort of granting full relief was because Mr. Chulai raised the objection that this is order akin to 144 CRPC, my lord, and there is an appellate remedy before the state government under 144. Now 163 BNSS, my lord. Now I have decisions on that, my lord, that these orders are, or the alternative remedy is not a complete bar to.
Have you given copy to
of the judgment, my lord?
Of your petition?
Yes.
Yes, would you like to respond? But this council would be on your side. So
this council has to be on my
main
side.
Contesting thing is the state.
Yes, Miss, tell me.
Your Lordship, Mr. Shulai is on next, and the matter come up after the Lordship, because the miss case, we have filed an affidavit of opposition to the main case. Lordship, the miss case was filed only yesterday.
So, Dr. Muziga, if they have filed the counter to the main case, we might as well proceed with the final.
I'm ready for that also.
That will solve the matter of once and for all. Because ancillary orders or proceeding will not help. In the long run, we have to proceed with the main course.
I'm ready for the final matter also.
If I can get a copy also, Your Lordship.
Please give them a copy.
You have received copy?
Yes.
Are you filing your rejoinder?
It's a question of law only, but my miscase for vacate, everything is on record, my lord.
That will be on record. It will be eventually disposed of along with the main.
I'm only praying for shorter date, my lord, in that case. Maybe next week. I'll not take. I'll keep it very short, my lord.
What is the urgency?
Urgency is leakage.
Is affected, my lord.
Leakage of revenue is huge.
You must. To maintain a check gate, you must be a moneyed man. So why would you?
He's sort of money now.
For us, it's leakage of revenue.
And the trucks are plying without any check now. That is what.
Heard, Mr. Yes, your colleague has already submitted. Dr. Musika has submitted that a separate misapplication has been filed in this regard, seeking interim relief. However, Miss Zadinokri Laraji, appearing for the state respondent, has submitted that in the meantime, the counter affidavit as regard the state respondent has already been filed. In response, the Dr. N. Muzika, Senior Counsel, hearing for the petitioner, has submitted that the matter, the main petition may be taken up for final hearing. Accordingly, this matter is now posted for hearing and listed to be listed after. How many? 2
weeks, Your Lordship. Only, Your Lordship, I have spoken today, Your Lordship. The question of maintainability of the revision may be kept open, Your Lordship.
Yes, at the time of hearing, you can raise that as a not preliminary issue, but as a combined issue, and that would be taken care of. Mr. Shulai Leonard AAG has also submitted that the issue of maintainability may be also taken up at the hearing of this petition.
Lord, I'm highly obliged, Lord.
Hello. On pre-made, list this matter to 2 weeks.
Obliged, Lord.
2 weeks.
Item number 5.
May it please your lordship. So my lord, on the last date, it was pointed out that union is yet to be served a copy, my lord. Union is yet to be noticed, and then it went that for me to take instructions whether to strike out the union or not, my lord. My instructions are, my lord, not to strike out the union because they are the one that this project, the money is funded from the union. Therefore, they are very necessary parties. So we are not striking out the union, my lord. So the state have raised certain preliminary objections to this, and they have also filed an application.
No, let the array of parties be complete.
Yes, my lord. Let a notice be issued to the union.
Is only a party here?
No, not yet, my lord. We have arrayed them as a party, but notice has not yet been issued.
Because the court did not deem fit to issue notice on the question of maintainability itself. That is why.
Even if we decide on here on maintainability, the union still have to be a party.
Yes, my lord. So let a notice be issued to the union, then we can have a hearing, my lord.
Mr. P. Yubin, Land Counsel for the petitioner, has submitted that at the outset, the petitioner may be allowed to take steps for issuance of notice upon the respondent number 5, Public Union of India. Since the same has not yet been resorted to by the petitioner, there is no express order of this court.
No, nothing, my lord.
Accordingly, on pre-made, same as allowed. Let notice be issued. The same returnable within 2 weeks.
2 weeks, my lord.
This is the matter thereafter.
Obliged.
It's 2019 matter.
Yes, my lord.
It's just been pending on the question of maintainability.
My lord. Anyway, let the union come. We can decide on that matter.
If you had taken step on the union since those years, you could have.
No, because it was stuck, as my friend said, it was stuck in the maintainability. We have, in fact, argued 2-3 rounds already. but anyway, my lord, let the union come.
Maintainability.
Yes.
With them or without them may be decided. But then,
yes.
Obliged.
Item number 7.
My lord, this matter is Lordship indulgence if Lordship posts the matter after the common prayer, me and my friend, due to some difficulties, my lord.
When?
Let me after a week, subject to convenience of the court, my lord.
On pre-made by the parties, let's this matter after 1 week.
After 1 week. Keep your objection.
Item number 8.
Yeah, my colleague wanted to seek some accommodation.
Some time.
When?
It's okay.
After 10 days or 2 weeks.
2 weeks. On pre-made by Dr. M. Musiga, Leonard, Senior Counsel, appearing for the respondent. Appearing for all the respondents?
Yes, ma'am.
For the respondent. The same not be objected to by Mr. P.J.K. Kanta, Leonard, Senior Counsel. Appearing for the petitioner, matters adjourned. This is after 2 weeks.
Yes.
Second call from supplementary list, item number 3.
Amit, this is your lordship. Lordship, kindly come again to that ultrasound report, your lordship.
Yes.
Lordship, kindly come to that kidneys.
Yes.
Calculus of size 5M noted in of left kidney, your lordship. Lordship, this has to be treated, your lordship.
So it has is enlarged or defect?
Lordship. So far this facilities, your lordship, even Shillong Civil Hospital also is not having the facility to treat this, your lordship.
You don't have?
We don't have, your lordship. But I don't know
What
into Tura, your lordship.
Negrims?
My lord, I have been Nigrim should have, but I am being treated by other doctors because I have a long history of diabetes, sugar also.
Where were you treated?
My lord, at Guwahati, then I have been treated at Delhi over a period of time. I visit Guwahati. Guwahati International Hospital, I think, has got the best, one of the best departments of nephrology.
No more international hospital.
My lord?
There's no more international hospital.
It has now become Apollo, but the Dr. Tanmoy Das, he's one of well-known nephrologist. So, my lord, and I am diabetic.
Yes, Mr. Ashla, I think.
Lordship.
Without going to the
On
other
medical
aspect,
condition, I will not say anything, your lordship. On medical condition, your lordship.
We'll not trouble this court with so much of literature.
Medical condition, your lordship. I'm not going to.
My lord, from yesterday has been dictating a lot of long judgments for bails. My lord.
Spare them.
My lord.
Heard Mr. N. Kira, Leonard, counsel for the petitioner. Accused. Oh, the petitioner himself is the accused?
My lord, he's the accused.
Petitioner accused.
Only on medical condition, your lordship.
Fine, we'll concentrate on that. Since you
only no other crown, your lordship, except on this crown only, your lordship. Because I'm
there's no
considering,
contention as far as that is what?
Your lordship, yes. After hearing from the after consulting the doctor, your lordship, that's why I'm not opposing, your lordship.
That is why you see,
Lordship.
it is always what should I say, profitable for us to go outside the box.
My lord.
If the court has not thought of the doctor here, you would have taken some time to
lordship, yes.
Get a medical board constituted.
Lordship will confine only on this crown, your lordship.
Right.
Highly obliged, your lordship.
Where's the FIR?
My lord, FIR is at page number, the operative 41, my lord. The folio is on top. The operative part is at 41.
Who has submitted that? White FIR dated.
My lord, it's 15th of May.
15?
My lord.
15 May 2024. Lodged by who is the complainant?
My lord, Starson Marak.
Lodged by one Shri Starson Marak before the officer in charge, Bajangdoba Police Station, Bajangdoba, North Garu Hills. The petitioner being named in the said complaint made therein, after going through the process of having been issued a notice under section 41A CRPC. 41A, at this point of time, I think BNSS is in operation.
My lord, I was issued a 41A notice back then.
When?
In May 2022, 24, 22nd of May 2024, I was issued a 41A notice.
Or this BNSS came to
Pre-BNSS,
BNSS
Your Lordship.
came
He
July.
appeared, Your Lordship. Yes, he appeared, Your Lordship.
Yeah.
In pursuant to that, he appeared, Your Lordship.
Sir, BNSS is from July, no?
Shuai Kato, I don't know. The FIR was taking cognizance of, and the case being Bajing Doba.
Bajingdoba, my lord.
What's the case number?
14/5 of 2024.
45 under section
379, my lord.
only 370.
403, 408, 409, 421 IPC, read with Section 7 of the Essential Commodities Act.
Was duly was registered and investigation followed. Ito ka section 41. After going through the process of having been issued a notice and was eventually arrested by the police on
14th of January 2025.
14th of January 2025 and is now in judicial custody. Next, what is the stage of the case? Charge sheet 25?
No, my lord, it's under investigation.
The learned counsel, apart from making his submission on certain legal aspect or certain contention raised, the same pertaining to the legal formality following an arrest of a person, has however stressed only on the fact that the petitioner, being in a critical stage of critical stage of his health, requires immediate medical attention, which may even entail hospitalization. The learned counsel has further submitted that this court, by its previous order dated
17th of February.
17th February, had directed medical examination of the petitioner, which was duly complied with by the authorities concerned. And today, the report of such medical examination was produced before this court by the prosecution. On perusal of the said report, the learned counsel has submitted that the opinion of the medical examination of the petitioner would reveal inter alia, that his kidney requires immediate medical attention. His kidney, liver, etc. requires immediate medical attention. On this ground and other related ground, the Learned Council has submitted that the petitioner may be enlarged on bail with any condition to be imposed by this court. Mr. Andy Shulai, Leonard AG, along with Ms. Arkundi, Leonard G, in all fairness, has conceded to the prayer made by the petitioner only to the aspect of medical attention, which requires the petitioner to be examined by a specialist or to be interned at any medical facility of his choice. Accordingly, it is submitted that if bail is to be considered, strict conditions may be imposed to ensure that the petitioner cooperate with the ongoing investigation. Anything else?
Lordship, yes. Only he should appear as and when called by the
those conditions are there.
Lordship, yes.
Accordingly, on consideration of the submission made and on perusal of the said medical report dated
26th, my lord, 26th of February.
26 to
25, Lord.
2025, pertaining to the medical condition of the petitioner herein, this court hereby directs that the petitioner be released on bail on the following condition: that he shall not abscond or tamper with the evidence and witnesses. He shall bind himself on a personal bond of rupees 50,000 with one solvent surety of like amount to the satisfaction of the IO concern.
My lord,
by the
magistrate.
By the magistrate concern, judicial magistrate.
Yes. He is being remanded from the
Lordship, yes.
by the magistrate concern. That he may avail medical attention at any medical facility within the country, but details of which should be intimated to the IO concern, details such as the name of the medical institute, the date or dates proposed to be the date or dates proposed to be admitted at such facility, and also he is to give his contact number and place of residence to the IO. That he shall not leave the jurisdiction of India without the prior permission of the IO. Anything else? In view of the above, this petition is hereby disposed of.
Apply, Your Lordship.
This would have been an interesting aspect to consider. Because you see, Mr. Shulai, he is talking about retrospective and prospective, application of the law.
My lord,
Lordship, on
matter is
in some other
But
case,
there-
Your Lordship.
there's the recent
Because
case.
he read, Your Lordship, I was listening to when he reads, Your Lordship, he say, henceforth, Your Lordship. So henceforth, that means, Your Lordship, it become prospective, Your Lordship, not retrospective, Your Lordship.
Perhaps, but there is a recent judgment just recently, I think,
Lordship, yes.
2 days ago.
Lordship, I read that judgment. I was about to make a submission on that, Your Lordship. Good judgment always has a retrospective effect. If it is specifically,
unless
Your Lordship. Lordship, I read that judgment in the life law, Your Lordship. Yes.
as we read in life law. So.
My lord, some matter has not been decided. So, for
Let
an academic discussion,
that issue became open, Your Lordship, in some other cases, Your Lordship.
my lord, since the matter is over now, the judgment very specifically says with regards to arrest after the pronouncement of judgment, even if we construct it for a future the registration of a case is immaterial because the guidelines in the judgments will kick into effect the moment I am arrested. And
No, we are talking about the aspect of prospective and retrospective effect of a judgment of the Supreme Court.
my lord, so
Because in that Bansal, you say henceforth. Henceforth, that means it will
So
become
I'm covered.
prospective, Your Lordship.
because my arrest happened in January, judgment is in October. Registration of case is, but my lord,
Those are details.
some other matter.
Those are details.
Apply, Your Lordship.
Thank you.
Highly obliged.